Are you okay, Madam Monitor?
Yes, it just came up. Thank you very much. Sorry
no
about
problem.
that. You're good to go.
I understand technical difficulties this morning. Good morning, everyone. Welcome to the Supreme Court. We have two matters down for argument today. The first is Halliday versus Commissioner. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. So please identify yourselves for the record and let me know whether you wish to have any time for rebuttal. You're muted, sir.
Okay.
Sorry about that, Your Honor. May it please the court, my name is Vishal Garg. I represent the petitioner, and I'd like to reserve 8 minutes for rebuttal, please.
Thank you very much. Justice McDonald will be our timekeeper, and you've been through this experience before, as I recall. Thank you very much. Whenever you're ready to proceed.
This case concerns the habeas court's decision to grant the respondent's motion for production and order the petitioner to turn over his prior counsel's case file to the respondent. The two issues before this court concern, first, whether that decision was subject to appeal, and second, whether materials in that case file were protected by a privilege. I'm going to start with the privilege issue. The critical issue there is waiver. The parties agree that there is an implied waiver of the privilege. The dispute is about the scope and timing of that waiver.
Counsel, Justice Ecker.
Counsel, before you get into the substance on the jurisdictional question, this case reminds me a lot of a case that this court decided a couple years ago. I think it was called Reading Life Care against Reading. Justice Doria authored it. The state cited it, and I'm not sure you responded. But, the holding in that case was that we just didn't have enough information. We didn't have a specific, definite court order to review, and we found that we didn't have jurisdiction as a result. It was about it was a claim of privilege. It wasn't attorney-client. It was some new privilege about an expert. It seems likewise here. I mean, there was an order to turn over the file subject to a privilege log and a determination of relevance. There's 10 banker's boxes of information here. I would think that the right way to proceed would be, as Attorney Baer pointed out on page 25 of her brief, in a sensible fashion, the lawyer has to go through, that is your office, or would have to go through all the files, every piece of paper, and determine the relevance, make a threshold determination of relevance, and make a determination of a privilege, whether work product or whatever. Make a privilege log, and then if there's disputes, you can bring it to the court. There may not be. I understand you have a timing issue because you want to preserve your right to keep your case wide open, but you're going to have to make some decisions about what's relevant, what's not. But, we don't know if there's a dispute here. We don't know how broad it is. What's your response to all that, sir?
So first, I think that there are concerns with producing a privilege log because it essentially gives the respondent an itemized list of the material deemed to have been privileged and not relevant in the file. And so it's still revealing the existence and nature of privileged material, even if it doesn't specify the exact substance of it.
Well, I'm going to interrupt you right there, sir, if I may. This is done all the time in civil litigation. Now, in criminal cases, there's not as much discovery, and so I understand it's arguably more foreign land, but it's done every day, and that's the whole point of a privilege log, is that you can identify as much possible information about the underlying document as can be done to allow for a ruling without revealing the privileged information. So I don't buy your first point. I mean, it's done all the time.
And I think the second point here is that and I think it's partly related to the first point, is that once that log gets created, So I think it's kind of hard to answer this question without going into some of the issues with the nature of the privilege. So part of the issue here is that counsel also objects to their own work product being created or being disclosed. And so I'm not sure whether or not that includes permission to list that on a privilege log.
Well, on that one, I mean, isn't the client has a right to the entire file? Wouldn't you agree?
I believe that it's a little bit more complicated than that.
So your claim is that there are portions of the client's file that the lawyer has a right to keep from the client's own review?
Yes. And that's.
Do you have a case that would? Do you have a single case that would support that proposition?
I don't believe there's a Connecticut case on point. I'm relying on Ethics Opinion 84.3, which essentially says that the attorney's work product belongs to the attorney and not to the client, and need not be disclosed to the client when providing the client with the client's file.
Well, I mean, I'm familiar with an attorney's lien where the attorney can, a retaining lien, where the attorney can keep the file and hold the file if they haven't been paid. Subject to court supervision, but I wasn't aware of any. I'll look at the 84.3, but I wasn't aware of any case that would ever provide that. But I've detained you long enough. So why don't you go ahead with your argument? And I'm sure my colleagues have questions.
Thank you very
Sure.
much. Attorney Garg, there's a question from Justice McDonald and then Justice Kahn.
Thank you. Well, sort of along the same lines, let's assume for the moment that this is a final judgment, and we need to get back to that at some point too. This discovery order was directed at your client, right? Not at the Office of the Chief Public Defender.
That's correct, Your Honor.
So are all of the bankers boxes that we're talking about in the possession of your client, or are they in the possession of the Office of Chief Public Defender?
I believe copies of them. I don't know if my client has possession of copies of all of them. I know that the petitioner was permitted to go in and inspect them. The actual physical banker's boxes that comprise counsel's file were, I think, still with the public defender, but I believe that either copies of those were turned over or that the petitioner was permitted to inspect those.
Is it your understanding that when a discovery request is served on your client, that obligates him to go out and acquire documents that he doesn't already have in his possession?
I think in this case, to the extent that he had access to them and would have been able to produce copies of them, it seems as though the discovery order was requiring him to do that.
Okay, and but the Office of Chief Public Defender was never served. I mean, you're essentially asserting a work product privilege, which is different than the attorney-client privilege, right?
Correct. Whose
privilege is the work product privilege?
It belongs to both the attorney and the client.
So how could the attorney or the client hand over work product that it belongs to the attorney without the attorney having been served with the discovery order?
That, I think, is exactly the problem here, is that the client's been ordered to turn over materials that he can't turn over the objection of his attorney, who has an independent work product privilege in that. I cited Ethics Opinion 84.3 for the existence of that privilege, but I think there are also independent cases that talk about it, mostly in the federal context, of the attorney having an independent work product privilege to prevent the disclosure of the attorney's material.
My final question, I guess, is this, or maybe it's partly observation. This is part of the problem when A habeas action is a civil action, but you have players who don't regularly participate in the civil process. Why wouldn't the proper way have been for the state to serve the office of chief public defender, and then the chief public defender would have had an opportunity to file a motion to quash the subpoena for the production of the documents, and then you would potentially have gotten to what the first issue is, whether or not a decision on that is a final judgment for purposes of appeal.
I mean, I think that would have been a proper way to do it. The fact that that wasn't done here, I think, is part of what creates a problem that necessitates the appeal, which is that the petitioner has been ordered to turn over stuff that at least arguably doesn't belong to him, and is kind of in between a rock and a hard place of deciding whether or not to either violate the court's order or potentially open himself up to liability by turning over material that is under a claim of ownership by a third party.
All right, well, that gets back to my original point. I don't understand how your client has an obligation to go out and acquire documents that are not in his possession to comply with the discovery order. Normally, it's what you have possession of that you need to turn over. Is that not correct?
I believe that's correct. And I don't know how clear the record was on this in terms of whether or not he had possession of all of the documents or whether or not he merely had access to them.
Thank you. Thank you.
Justice Khan?
You're muted, Your Honor.
Still muted, Justice Khan.
Can you hear me now? I'm so sorry. There's apparently a huge delay and the bar doesn't come up even when you hit click. I apologize. Counsel, I have two questions for you. One is follows up on both questions you've been asked already. Justice Ecker is absolutely correct. Privilege logs are produced all the time, not only in civil cases, but in criminal cases. It's routinely done in federal court. So I fail to see how a privilege log, which is the proper method to be used, would disclose anything that would be work product. In other words, just like attorney-client privilege, you can produce a privilege log that just indicates what it is, whether it's a document, a letter, a memo, and a general description without disclosing the content of it and protect it. So, I don't see how, I don't follow your argument that you would be disclosing the content of anything by producing a privilege log, and how that would harm your client's interests. But my biggest concern is if your client's not in possession of some of these records and the file belongs to your client, I thought that was what the case law typically would say. It doesn't belong to the lawyer, it belongs to the client. How does your client then have standing to assert the work product privilege?
So I believe the client has standing to assert aggrievement from the decision that orders him to turn over work product.
But if it's not his work, if it's not his privilege, how does he have standing to assert it?
So he's not the one asserting the privilege. Counsel asserted the privilege. The problem is that he's been ordered to turn over this material that is protected by the privilege, and that's the reason for the appeal, is that he can't do that without subjecting himself to liability for turning over materials that he's been told not to turn over and that don't belong to him.
I thought, though, okay, so your client has them and has been told not to turn them over.
He does not have them. I believe he has some of them. I believe that he certainly has access. He could go in and make copies, or at least his attorney could go in and make copies of anything that they don't physically have.
Okay. Parties are often asked to, unless there's a claim of attorney-client privilege, are often asked to produce records that they didn't create themselves necessarily or weren't originally in their possession. For example, the state is required to turn over its file, even if it has interview reports or other information that belongs to police department or some other entity, correct?
Correct.
Okay. So I guess I'm still struggling with, why is the procedure laid out on page 25 of the state's brief? How does that harm your client's interests in any way? It would allow for both the attorney-client privilege to be asserted and the work product claim to be asserted, and then presumably resolved by the court in camera. Why shouldn't we let that process happen?
I think this court could remand to create a privilege log and then have the case back up here after that. But I think there are a couple of problems with the process of doing that. The first is that any description of the kinds of materials is either going to be too vague to allow the court to rule, or is going to need to be specific enough such that it is revealing the actual nature of the work product involved. I mean, just as an example.
Isn't that what happens all the time, counsel? That's what privilege logs do. What you're arguing seems to be, for some reason in this case, a privilege log, which is the traditional route to go, would never work. My question to you, my final question to you would be this, because I notice Justice Doria also has his hand up and I don't want to take up all your time. So my final question is this. If the attorney had been grieved, there had been a grievance filed against the attorney, raising perhaps related to these claims, and the attorney was defending either a grievance or a legal malpractice lawsuit, would the attorney then be able to use the work product without even consulting with your client? Presumably they could waive the privilege and turn it over, and they certainly would, right? If there's something in work product explained why they weren't unethical or why the lawyer wasn't incompetent.
Yes, I think if they chose to waive the work product, I think at that point you'd have to ask whether or not the implied waiver from the client exists. Certainly once the hearing starts, that would exist. So the attorney would certainly be permitted to turn that over to have it put into evidence.
The work product. I'm talking about the work product, not the attorney-client privilege.
Oh, yes, I believe counsel would be able to turn over work product at that point.
Thank you. Thank you, Chief. Thank you, Justice Doria.
You're welcome, Justice Khan. Justice Doria.
You're on mute, Your Honor.
Thank you. Thank you, Chief and Justice Khan, for that introduction. So how confident are you, counsel, that you can assert a work product privilege on behalf of the public defender's office? I always thought when you have stuff that is privileged, you can tell somebody, I'm turning this over unless you come in and do something about it, and they can come in and assert. Am I wrong about that in this context?
So I think you're not wrong. I think what happened here was when that conversation happened, my understanding is that the petitioner's trial counsel, and this is, I think, it's either on the record at the last hearing or it was put in a motion for, I think, reconsideration, is that there was a conversation between the petitioner or the petitioner's counsel and counsel for the public defender's office. The public defender's counsel represented that the materials or the work product in the file belonged to the public defender and that the petitioner was not being permitted to turn that over. I don't believe that they came to a hearing after that.
So this is, I'm going to ask Attorney Baer a similar question, just about, how you all get to a resolution of this. So it frames, I think, our view of this particular question. But it seems like we have an issue coming before us that we have no law on. Attorney-client, I guess, has not come up here in this context in habeas. The state says it's an issue of first impression. And we have very absolute positions being taken by you, by the court, and I guess by the state. I mean, the state wants everything. I don't know if that's usual. Maybe you can tell us whether that happens routinely in habeas. But it's hard, and this kind of goes to the final judgment question, but it also is kind of a prudential ripeness sort of issue. Usually we would try to tease out what a privilege is or any area of the law by looking at some documents and figuring out what. So can you react to that as sort of framing your final judgment? Why would we be deciding this or asking somebody to decide this now?
Sure. I mean, I think that there are a couple of issues here. I mean, I think that the court can decide the question as to whether or not the order was proper without there actually being a full a privilege log stating what is and isn't in the file. And I think part of the reason for that is that there, I think, certainly are materials that are relevant in the file that the petitioner claims remain protected by the privilege. Going back to something that you said earlier, it is highly unusual for the respondent in a habeas case to request an entire file. And I think it's a little bit important to go through a little bit of the history of discovery in this case. Initially, the respondent requested, so the parties engaged in informal discovery, which is fairly standard. The respondent then requested all materials that had been provided to the petitioner's mental health expert. That was ordered, turned over, and was turned over. The respondent then requested an entire copy of counsel's file, which was denied. The respondent renewed that request with some limitations after the case was moved to a new court, and the request was then granted. So I do think, I mean, the petitioner is in a position where he kind of has to take an absolute position now, because he has already turned over the materials that have been requested. And the respondent in this case has asserted repeatedly that the respondent would be satisfied with nothing less than the entire file. Here, the respondent spoke with counsel for 45 minutes. They were fully forthcoming, answered all of counsel's questions, indicated no memory lapse. And the respondent came back and said, I'm not going to be satisfied with that. Even if they're fully forthcoming, I'm not going to be satisfied. I want the entire file. The respondent has made no showing as to why it needs this file, why it has any sort of compelling or substantial need. Time is up. May I finish my thought, or?
You may.
Thank you, Your Honor. The respondent hasn't shown why it has any need for the file or why it would be prejudiced without it. It hasn't even suggested any materials that might be in that file that it believes that it's entitled to, or explained why it needs it. In light of that, I think whatever privilege remains in the file is sufficient to override the respondent's request. And I will save the rest of my time for rebuttal. Thank you.
I believe, Justice Khan, do you still have a question? Your hand's up and I don't get any longer. You just muted yourself.
So there's about a 30-second delay when you hit the button, and then if you leave the cursor, it unmutes you again. I apologize. I did, but I'll wait till rebuttal to ask the question so as not to take up time. Thank you.
Thank you very much. Attorney Baer.
May it please the court, my name is Catherine Baer. I'm a senior assistant state's attorney here on behalf of the respondent commissioner of correction in this appeal. This appeal really starts and ends with the first issue, which requires this court to assess whether there is a final judgment.
Justice Doria.
Let me just make sure I'm not muted. Yeah, okay, I'm not muted. I'm sorry to do this, Attorney Bear. I hated when people did it to me, but I think you can handle it. If you could just maybe frame for us this dispute, it's useful to me at least to kind of know, especially when government agencies are at issue, what the origins of the dispute are. Why is this coming up now? Why do we have no case law about this? I know this is a compound question, but do state's attorneys rarely ask for this kind of discovery? Do they just live with a grant or a denial? Is it just that you got a judge who was willing to engage on this and they're usually denied? Is there something about this particular case or this particular habeas, or was there a change in tactic or policy by the Chief State's Attorney's Office? Could you speak to that just generally?
Absolutely. As far as I'm aware, there's no change in tactic or policy. My understanding from speaking both with the habeas trial prosecutor in this case and in other habeas matters that I've had the opportunity to work on, that for the most part, the parties have been able to follow Practice Rule 2338 and engage in informal discovery. And in fact, from speaking with the trial prosecutor in this instance, she had indicated that, as a matter of course, a lot of times the entire file was turned over just informally when there were ineffective assistance claims alleged. I don't know if Your Honor wishes me to.
You can keep responding to me. Justice Ecker's just getting in the queue.
Okay, very good. So, and then frankly, if it wasn't being if the entire file wasn't turned over, the trial prosecutor just had to make a decision as to whether it was worth pressing the issue or not. I think, frankly, once Judge Feger issued that decision in Breton back in 2006, I think that had provided some guidance in the area of implied waiver, or they applied federal law, which seems pretty well settled in this area.
Could you react to this? What you put down as sort of the procedure that you would suggest maybe sounds reasonable. It sounds like a rule. It sounds like something the Rules Committee could look at. I mean, we have a rule.
I'm sorry.
Limited discovery.
Just Daria,
Yeah.
we're getting an echo
Mike's
and
close.
some kind of strange background sound from you.
I'm having a lot of feedback.
Could you
Let me
speak
see
the story so I can see
Is it me, Roberta?
it stopped?
I think it may have been because Attorney Bear's microphone wasn't muted.
Okay. And
We're
so
good.
I'll just, am I okay to go on, Chief? So I guess you can react to that. It feels like a rule to me. We have a rule that is very limited in discovery, but is it better? I mean, I know you have a final judgment position, and so, you know, it maybe goes to that, but is this better to be litigated in a case, or should we get a rule? I mean, I would hate for only Judge Blue's litigants to be subject to this.
I think what Your Honor is getting at gets into a little bit of a tricky area in terms of creating a rule that would, to the extent that it would intersect with the Sixth Amendment and the effective assistance of counsel. I think it would be something that might be beyond the purview of the Rules Committee. So I think this is an area where, to the extent that the constitutional implications of the right to the effective assistance of counsel come into play, it might be a slightly blurry area that might not be totally amenable to rules. But certainly in a more generic sense, could the Rules Committee create process? Absolutely.
Okay, I take that point. Good, thank you.
Justice Ecker?
My question, I guess, follows from the conversation you just had, or the discussion with Justice Doria. ABA formal, and it relates to the formality or informality of the process. From reading ABA Formal Opinion 10456, right, which was 2010, it really sounds, according to the ethics people, at least, or some of them, like it's very, very dangerous for counsel to proceed on an informal basis. And in fact, the whole point of that formal opinion, which is it's attached to the amicus brief. I don't know if you're familiar with it, but it really seems to count on every page, seems to counsel against informality and say, look, this should be done under judicial supervision. And I can see good reason why. And in fact, your proposal on page 25 seems to contemplate that, because there's a very large risk on whether it's a property-based risk or something else. There's a big risk on the part of third-party counsel to do any direct turnover anyway. I understand it wasn't necessarily raised in this case because it went through petitioner's counsel. But anyway, if you can comment on that point and the need for judicial supervision at some level, I'd appreciate it.
I would agree that I think that's why there needs to be a procedure either endorsed by this court or perhaps rules that allow for this possibility of court intervention. Because even as, there were a couple district court of Connecticut decisions, lower court decisions cited in the respondent's brief that touched on this as well. The problem, of course, right, always the rub here with habeas state litigation is purely numbers. And I think the petitioner takes the respondent to task a little bit in his reply brief that efficacy shouldn't dictate law. Well, and that's not what we're saying, but we can't ignore it either. I mean, the fact is, an evidentiary hearing in every single case involving ineffective assistance of counsel would be quite burdensome, and there should be an allocation of duty to do some of the legwork on the part of counsel first, and then have that opportunity to bring any disputed areas to a court for judicial intervention.
Justice Khan.
Thank you, Chief. And I saw Justice Secker nodding, so it sounded like he too was done with his questioning. So this is a follow-up to that. In fact, Judge Kravitz, in the decision that is attached to your brief, points out that even in the federal system, they want lawyers to meet and try to resolve, turn over what there's no objection to, and then create a privilege log to what is objected to, whether that be work product or attorney-client privilege. I too have issues around whether this is a final judgment or not, and whether the work product claim was adequately preserved below or not. But it seems to me that, like the federal system in habeas, if we're going to require the trial courts to litigate these discovery disputes without even letting, in every case, without letting the lawyers first try to figure out whether there even is a dispute. And if there is, produce a privilege log, and then the court can decide it. Otherwise, it would seem like habeas petitioners wouldn't even get to their case for a long time. I doubt that either the state's attorney's office or the chief public defender's office wants to spend resources litigating issues that may never need to be litigated because the parties agree. It may be that the state looks at a privilege log and says, typically a party would say, look, I looked at the privilege log. I don't take issue with items 2, 3, 4, 5, but 7 and 8. I think we're entitled to, because it's either a time frame or relates to an issue that's been filed. I think, doesn't it really come down to the issue of, once there's a claim of ineffective assistance, there's an automatic implied waiver of the attorney-client privilege. And if the claim relates to attorney incompetence as well, obviously ineffective, that there's an implied waiver to work product. And then the onus is on the party to claim that it's not relevant. So this gets to my final question to you is, don't you think that the federal cases, one, support the notion that we wouldn't do this up front? In other words, that the parties would try to resolve these issues. And two, my final question is, if you do that, well, let me have you answer the first question, and then I'll ask the final.
Yes, Your Honor has summarized the respondent's position, which is that it is an implied waiver at the time that the claim of ineffective assistance is alleged. and that federal case law would support that. I would also point out the Pennsylvania Supreme Court grappled with this issue back in 2016. That decision is cited in the respondent's brief, Commonwealth versus Floor, FLOR. That was actually a case where the petitioner's counsel had asked for the opportunity, let me go through the files. There had been a discovery order. The trial court said you have to turn over everything relevant to the claims. And petitioner's counsel asked for the opportunity to be able to go through the files first, and the trial court had said no. And ultimately, the Supreme Court in Pennsylvania ended up saying, yes, you have to give petitioner's counsel this opportunity to sift through, create this privilege log, and all of the rest.
And my final question is, as I read Judge Blue's opinion order, he's not saying turn over the entire file. He's saying turn over those portions of the file that relate to the claims of ineffective assistance. So I did not read his order as saying turn over 100% of the file, but rather go through the file, turn over what relates to the issues, and if you have claims of privilege, then bring those to the court's attention.
That's exactly right, and it's something I wanted to be clear on here today with the court, that while the initial motion filed by the respondent had requested copies of all defense file materials, although interesting, this goes to a question from Justice McDonald to my opponent, that initial motion clarified that are in his possession. It was the second motion where the state requested copies of any materials contained within the underlying criminal defense files that relate to his claim. And that is what Judge Blue ruled. That second motion, of course, can be found in the petitioner's appendix on A77. And I want to address the point that was raised by Justice McDonald earlier, this idea of couldn't the state have filed something on the Office of the Chief Public Defenders? It's not clear at what, well, no, let me back up. I think it's abundantly clear that it was not, the respondent was not aware of who possessed the files or where they were until after Judge Blue issued its ruling. And in fact, there were representations made by petitioner's counsel during the February 22nd, 2019 proceedings, where petitioner's counsel was talking about going through the materials. This is on page 17 of that February 22nd transcript. And she's indicating, this is counsel for the petitioner below, I would have to call the New Haven office because some of the files are still in boxes here. I have to see if I can get someone to pull someone from my office to assist with any kind of privilege log. There are implicit representations that petitioner's counsel has access to everything. And so it's not entirely clear that the respondent knew of this duty. Even if it did, it wasn't until after Judge Blue issued its ruling in early March, and after this appeal had been filed on March 15th, that for the first time in that motion for reconsideration, that this issue of the Office of the Chief Public Defender having the interest was explicitly made to the court.
Anything further, Justice Khan? Justice McDonald and Justice Doria.
Thanks, Chief. Well, let me ask you, first of all, for work product, whose privilege is it?
The amicus concedes on page 3 of their brief that the habeas petitioner can waive the privilege.
Can waive the work product privilege?
Yes, Your Honor.
So I have to go back and dust off the research I did when I was in private practice. The privilege of gaining access to the thoughts and impressions of the attorney, regardless of whether they are ultimately used in the prior litigation, those are the privilege of the client, not the attorney?
Well, I think at a minimum they belong to both, or at least that's what petitioner's counsel has, I think, agreed to.
No, what does our case law say?
I don't know that our case law is clear on this point. It hasn't been litigated frequently, and so I'm not sure that's entirely clear.
Okay, let's assume for the moment that the privilege at least includes the attorney having a privilege on the work product. Why, and I understand you're just here on the appeal, why would it not be trial counsel's obligation to notify the attorney whose privilege is involved that he or she may have to assert that privilege in court? Why isn't it the proper methodology to serve a subpoena on the Office of Chief Public Defender so that the issue could be joined in court so that privilege could be resolved?
Why is it not required? What was the language that Your Honor used in the question?
Yeah, I mean, if the privilege is the attorney's, at least in part, does the attorney not have to have notice that their privilege is at stake and an opportunity to be heard?
That certainly seems to make sense. Do I know of a case or a rule requiring that? No, I do not. But the other thing is this whole discussion with the lack of clarity here, or to the extent that this ownership issue is not fleshed out, is all the more reason why this is an improper ruling for this court to be reviewing at that time. As I've pointed out in my brief, there very well might be more litigation related to these issues, particularly given the timing of the raising of the work product issue, which as I set forth is really, as was really more presented as this property type issue, may well occur prior to this issue globally being resolved in the pending habeas matter.
Thank you.
Justice Daria.
So, what you said to my last question about rules was, probably because of Sixth Amendment issues, it needs a litigated case at some point. We don't have any law. It seems like is some of your answer to Justice McDonald on particular issues of privilege, and maybe you're making the final judgment, argument somewhat reluctantly. I won't put words in your mouth, but you feel like you have to because that's our case law. Can you tell me when you think it would be final, or when? I mean, there are other avenues, I guess, to get this issue before the court, because usually, I think the case used to be Melia that would say you have to go to the end of the case. I don't know if that's still the precedent. I should know that, but and unfortunately, the petitioner has a real case. It's himself. It's his privilege. So, when would you think this would be final enough for a ruling? Everybody claim the privilege that they need to, and we have documents. What have you given that some thought?
I think typically those issues have been litigated once a privilege log is produced, and then if there's any further dispute as to what portions of that privilege log are going to be turned over, that's when it usually comes before the court.
Before the trial court, but when do you think? Does he have to lose his habeas for it to come up here? That's usually the case in discovery disputes.
Yes, and to answer the first part of Your Honor's question, Melia would still be controlling in the respondent's view, in that this would have to wait until the end of the habeas litigation, and that's because there are mechanisms for protecting the privilege as the matter is litigated, namely potentially sealing orders or protective order, in-camera view, and the like. Now, there are other avenues that this appeal could have presented itself to this court. That would have been a public interest application by, of course, a party, or had the public defender's office intervened, I think you'd be in the more traditional area in our cursio jurisprudence in terms of a non-party having that separate and severable action ruled on, and then thereby permitting review under a cursio prong at that point. But
so the state isn't dead set against having this litigated before any particular petition or wins or loses his case. I mean, you might be able to do a reservation. You could agree on a factual record or something. And I mean, this is going to come up in every case. I don't understand why it doesn't come up in every case. And if your suggestion is we can't do this by rule, maybe everybody could get a real case before us at some point without him having to lose his case. Although he might prevail.
There are avenues to do that, yes. And, I think the petitioner has pointed out, while a public interest application was not pursued in this matter, there have been extraordinary circumstances where Komos-Sarjevsky back in 2011 being the most recent, where effectively the appeal was treated as a public interest application after the appeal had already been filed. The only problem with that from the respondent's point of view is that, two things really. Number one, it is sort of an unusual procedure, and it's unclear whether that's really good policy for the court to sort of direct the process of appellate litigation. Number two, there were some timing issues that were really in play in Komos-Sarjevsky. Namely, that involved the disclosure of the contents of the witness list. The appeal came up before the court in June. The evidentiary portion of the criminal trial was set to begin in September. And of course, this court ended up treating it as a public interest application and releasing a decision in August prior to the evidentiary portion beginning. So those are some things that would militate against sort of sua sponte considering this as a public interest appeal.
Anything further, Justice Daria? Justice Acker.
I mean, another thing that would militate against treating it as a public interest appeal now is that, the final judgment rule, it's not just a formal rule, there's a reason behind it. One of which is, I just don't know, this goes back to, I guess, something I was talking with Attorney Garg about. I'm not sure we have enough information right now. In fact, I'm pretty sure we don't. We don't know if there's a real dispute because counsel could go through, right now they've taken almost a property-based, you don't have the right to have these. But maybe they'll go through the files and find out there's nothing in there to hide from and nothing in there to be protected, I should say, and it's all fine. Maybe they'll reduce it to 2 documents. Maybe there's a document in there in which the lawyer wrote down, I think this guy's guilty, and then we'd have an issue where, there'd claim no relevance, there'd be some objection, and Judge Blue could address it in the first instance. But at this point, we just don't know. Isn't that a real problem with taking the case in its current posture?
Absolutely. I mean, for all the reasons that Your Honor just stated, the fact that we're at this sort of embryonic stage, we at least need to get further into actual orders that are specific and concrete as to what is being turned over or not, or what have you, in order for this court, frankly, in the response view, to issue sort of any intelligible ruling with respect to the merits of the appeal. There's also sort of an inconsistency underlying the petitioner's position, where below petitioner's counsel agreed readily that the respondents would be free to talk with counsel prior to trial, but not have access to the materials. It was just something I wanted to note, that it seems to cut against common sense. Now, I know Attorney Garg is pressing for this sort of at the time of trial, or potentially when when criminal trial counsel testifies during the actually evidentiary hearing. But it seems to me that, and again, this goes to this overriding truth-seeking process that the discovery process serves. That's really what is at issue here, and that's the prejudice. And Judge Blue nailed it in his during that February 22nd proceeding. It's at page A189 of the petitioner's appendix, that the prejudice is the fair litigation of the claims, that the petitioner has placed in issue the very conduct and potentially contents of the criminal proceedings, and it's ultimately the truth-seeking process that suffers here. I did want to make clear, because I think the petitioner takes a sort of a contrary view. Counsel for the respondent below represented, and this can be found in the petitioner's appendix at page A185, that she had spoken with the two attorneys who represented the petitioner during the criminal proceedings. They could talk about various things, including their defense theories, how they divided the labor, and what they worked on together. But she did represent that there were many, many nuances that they could not recall, and that was the basis for the motion. And again, this goes back to Justice Kahn's point. At that point, the respondent wasn't moving to get the entire file. They were moving to get the materials that were relevant to the claims. And when the claims are as broad-reaching as they are in this case, which included failure to conduct an adequate factual investigation, failure to adequately research the legal issues, failure to adequately prepare a defense, as Judge Blue indicated, I mean, it's hard to imagine what's not relevant to the claims having such breadth as they do in this case. And that's the petitioner's right, absolutely. But it's also part of his decision and his attorney's decision about what claims to bring and what claims not to bring. If I could just get a moment.
Counsel.
A point I just want to make about the work product rule, we have to recall too, and of course I stand by our position that it's not even that issue isn't before this court, but the rule derives from Hickman versus Taylor, 1947 U.S. Supreme Court decision, and the purpose underlying the rule was to protect the lawyer during the adversarial proceedings from those notes, that research, doing all that legwork, and then effectively having your opponent be able to reach in at the last minute and get access to that material, which causes this inherent unfairness. The interests are much different in the habeas context, where that matter has concluded. The criminal prosecution is completed. There may or may not have been a direct appeal that's gone to resolution. At that point in time, the purpose underlying the work product is no longer being served, in the sense that it's not me saying to Attorney Garg prior to today, hey, hand me your notes before oral argument so that I know what you're going to talk about. It's what happened in this earlier proceeding that has now concluded. So the interests are very different.
Senior Associate Justice McDonald.
Thank you, Chief. Counsel, I just did some brief research and found a couple of cases where, for odd reasons, the request was for the work product of the prosecutor. And in that situation, where you're representing the state, you don't have a client. It's only the work product, so only the attorney can assert the work product privilege. Is that not correct?
That would be correct.
So doesn't that inform this analysis that the privilege really is the Office of Chief Public Defender and not the privilege of the petitioner?
It may well be. I would just point the court to the fact that the public defenders themselves, in their amicus submission, agree that the petitioner can waive the privilege. So,
how can the petitioner waive the attorney's privilege?
With respect to work product, and again, maybe this kind of kicks into that ownership issue. If the petitioner has copies of it in his possession at the time when he's litigating a claim where he's placing in issue the work, the mental impressions of that attorney, it would seem to me that in that instance, the petitioner would have to turn them over. Now, whether, as you suggested, that attorney itself, him or herself, needs to intervene, assert a right, and litigate it that way. But again, in a vacuum of case law on this issue, I don't know that we have definite answers.
Thank you.
Thank you.
Anything further, counsel?
No, thank you very much.
Thank you. Attorney Garg.
Thank you, Your Honor. I think the first thing I want to address is this question of whether or not this should be done via rules rather than through litigation. And I do want to point out that in pretty much every other jurisdiction, there are specific discovery rules that I think at least give some guidance as to this. And I think that's part of the problem with relying on federal cases when deciding how to rule here. In federal habeas, discovery is governed by the federal civil discovery rules. In Connecticut, discovery is expressly not governed by those rules. But I do think that, I mean, to the extent that procedures could be developed for this, I do think that that should go through the Rules Committee. I also think it's important to point out this fairness issue that the respondent keeps kind of coming back to. And specifically, the respondent isn't able to give any specifics about how it would be harmed. I mean, there is this sort of general notion of litigation would be more fair if the respondent had access to everything that the petitioner had access to. And I think that that's probably true. If the parties mutually had access to all of the same information, litigation would be more fair. However, our practice book has expressly decided that the parties aren't going to have, as a matter of right, access to all of the same information. And instead, the only thing that they have a right to is a witness list and to disclosures of experts. And so to the extent that what the respondent is asking is that this court finds that fairness promotes complete discovery in all cases, I think that's a request that needs to be made to the Rules Committee and not to this court. I also do want to point out a couple of things. I don't think, looking at the amicus brief, it's not clear to me that they're conceding that the petitioner can waive the work product privilege on his behalf. I mean, the petitioner's position in this case is that both the client and the attorney have independent rights to assert the work product privilege. And so even if the petitioner waives his side of it, I think before it can be turned over, the attorney also needs to waive their side of it. And I also want to point out, I think the respondent may have missed a couple of things in terms of what the respondent's counsel below said. The respondent's counsel below, when talking about the petitioner's trial counsel not remembering things, says, and this is on page A185 of the petitioner's brief, there must be many, many details and nuances that they don't recall. And so there's no suggestion that counsel ever answered a question with, I don't remember. It's just this kind of speculation that there's going to be things that they don't remember, and I need the file to know all of those, even though they haven't told me that there are things they don't remember. And I will defer to the questions. I don't know who is first.
Justice McDonald, then Justice Kahn.
Based on your answer that the privilege for the work product is both the clients and the attorneys, why wasn't it incumbent upon the petitioner to cite in the Office of Chief Public Defender to join this issue properly in the trial court?
I think it should have been incumbent on the respondent because the respondent is the one who is seeking to pierce the privilege. So I think the respondent ought to have notified the Office of the Chief Public Defender that it was making this request. Certainly, I think the petitioner could have done that, but to the extent that the respondent is requesting counsel's work product, and I do want to clarify, I mean, the motion for production specifically requests counsel's work products. I think it.
Counsel, the problem I'm having is this with this being the petitioner doing this. This is nothing other than a discovery dispute, which is not a final judgment. Had the attorney been subpoenaed and there was a resolution of the attorney's privilege, that would have been a final judgment for purposes of appeal, would it not, under our existing law?
Yes.
So I mean, you're right. It probably would have been great for the state to have initially given notice to the Office of Chief Public Defender. But doesn't that still present a problem for you that the OCPD was not a part of this resolution at the trial court level?
It does in terms of the final judgment issue. I think, however, that the case is, and I think you're referring to, it was Abreu and Woodbury Knoll. I think the only difference there is one of standing. And here, I believe the petitioner does have standing for the reasons that I said before. He's essentially in this position where he has to do something that could expose him to legal consequences, either from the court or from prior counsel.
Justice Khan.
Thank you, Chief. Counsel, my question is similar in a way to Justice McDonald's question, and that is, you said the work product privilege is duly asserted. So even if your client had waived it by raising claims relevant to it, there would still need to be a waiver by counsel to turn those documents over. So my question to you is, if your client, instead of a habeas, had filed a grievance against his attorney, claiming either an ethical violation or say even a malpractice claim, are you saying that the attorney could not, in defense of such a claim, produce work product? He would need your client's permission to introduce work product privilege that he retains to defend that claim?
No, and it's the same thing. I think we agree that there is an implied waiver. However,
why not? Why not? Counsel, just stop a moment. So you, in that situation, you're saying no, the attorney doesn't need your client's waiver to use those documents, meaning there's an implied waiver. Is that what you're saying?
Correct. And we agree that there is an implied waiver in the habeas context. Our assertion is that the implied waiver doesn't become effective until the petitioner presents evidence. And when you look at the cases, a lot of them rely on the presentation of evidence as the time at which the implied waiver becomes effective.
Why do we have to wait for evidence? It seems that you're saying basically it doesn't kick in until the trial. What happens to counsel preparing? Now you turn over 10 boxes of documents and counsel says, I just got these this morning. Now do we have to postpone the trial for counsel to review those?
Yes, and may I respond to that question? My time is up. I just want to make sure.
You may, counsel.
Okay. Yes, and I think there's a couple of reasons for waiting until the time of trial. The first is that it best protects the privilege. Going in, if the petitioner, say, has a claim that a witness, counsel should have called a witness who had heard some third party confess to the crime, turning over materials before trial means they get, the investigative report, describing the witness's testimony, maybe counsel's notes on a meeting about the witness's credibility, maybe counsel's notes about the witness's criminal history, all sorts of information pertaining to that witness. If we wait until the time of trial and counsel says, well, I didn't call that witness because I wasn't going to present someone who had 2 larceny convictions because the jury wasn't going to trust that guy, then we only need to turn over the materials that we know are actually relevant to defend the case. And we protected the privilege with respect to the remainder of counsel's work products. And because there's no depositions in habeas, because counsel and the petitioner are often at odds, we don't know how counsel is going to defend himself in the case until the time of trial when counsel comes out and says, here's my reason for doing this. And that's the point at which I think it's fair to make the determination as to what gets turned over. I realize that that means that there's often going to be a delay. And I would point out that it's fairly typical in habeas cases when an extra day is needed for that day to be several weeks or months down the road. I've had cases that have lasted more than a year because of the realities of habeas. The docket is clogged and it's often difficult to find a day that works for everyone until several months out. And so even though that does sort of, at a glance, that sounds like a problem, we're going to have to wait a month before we can get back and do the cross-examination. That's actually not that unusual for habeas cases. And if there are no further questions, I will rely on the briefs and the argument that I've made up until this point. Thank you.
Thank you very much, counsel. With that, we will be in recess until the next matter, which I believe starts in 6 minutes. Thank you very much.
Thank you, Your Honor.
I believe we are on the record, Your Honor.
Thank you very much. The next matter on the court's calendar is State versus Dawson. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Counsel, are you ready to proceed? Okay, please remember to turn your microphone on. Thank you. Identify yourself for the record and let me know whether you wish to reserve any time for rebuttal.
Yes, Your Honor. May it please the court, my name is Erica Barber. I am the assigned counsel for the defendant appellant in this case, Mr. Andre Dawson. With the court's permission, I'd ask to reserve 7 minutes for rebuttal.
Thank you very much. Justice McDonald will be our timekeeper. He'll let you know when the amount of time you have left and when your argument is over. Thank you very much.
Thank you. Although trial by jury is a cornerstone of our criminal justice system, juries sometimes convict defendants based on evidence that is insufficient to establish guilt beyond a reasonable doubt. This is such a case. The gun was found in an outdoor courtyard where multiple people were present. The doctrine of constructive possession and our cases protect innocent people from being convicted of possessory offenses merely based on their proximity to contraband. The state's theory of liability in this case required it to show that Mr. Dawson had knowledge of the firearm and that he had the power to control the firearm and that he intended to exercise that power and control. To do that in this case, the state was required to identify additional incriminating conduct or circumstances from which the jury could infer that Mr. Dawson, as opposed to some other person at the Washington Village housing complex, constructively possessed the firearm. The weak and circumstantial evidence in this case, presented by the prosecution, provided no way for the jury. Yes, Your Honor.
There's a question from Justice Khan.
Yes.
Thank you, Chief. Counsel, my question is this, and I understand your arguments on the Lynch and Beverly case. They're definitely distinguishable, and I get that. But in this case, it sounds like the jury, even as your brief outlines, heard testimony from the DNA expert that DNA can be present on an item either by touch or by somebody, dropping DNA. They cough, they sneeze on something, they don't necessarily have it in their possession. Given that the jury was presented with that theory and that it was argued, if we, how are we to reverse the jury's finding? In other words, the jury heard one way that that his DNA could have wound up on the gun is he picked it up, touched it. State's theory presumably is that he tossed it when he heard the police coming, because no one seemed to testify that he moved from the bench, correct?
That's correct, Your Honor.
So the state's theory was that he tossed the gun, that it was in his possession, and that's how his DNA got on it. His position was, hey, his DNA got on it because he might have gone near it at some point and sneezed or something else, but it wasn't in his possession because he wasn't allowed to possess a gun. If the jury was presented with both theories and the expert's testimony, why should this court reverse that finding by the jury? It seems then the jury believed that his DNA was on it because at some point he possessed it before the police found it.
Well, Your Honor, I think the simple answer is that based on this record, the record that the jury had before it, it had no basis to make that conclusion. And to be clear, the expert testimony in this case, as you suggested, was that the DNA could have ended up on the firearm in any number of ways. So where we draw the line between a reasonable inference and an unreasonable inference is difficult, admittedly. State versus Billy is a very good case. It's cited, I believe, on page 15 of my opening brief. It's not the exact same situation, but the case there was that drugs were in a high crime area. There was testimony that the defendant was under surveillance. He went to a porch where there were drugs stashed, and a lieutenant in that case testified that both users, so it's sort of a dynamic here where dealers were stashing drugs in the neighborhood, and users were then stealing those drugs that were stashed. And the appellate court said, well, I mean, the jury hears both. How do you determine in that case whether he was a user or a dealer? Because in that case, obviously, it was possession with intent to distribute. So that's similar to the case that we have here. And in Billy, there was additional evidence that, in fact, it was previously his residence.
But is it really different when you don't dispute that he was never allowed to possess a gun, right? This was a criminal possession of a weapon.
Yes, Your Honor.
He was never, whether it's a minute, 5 minutes, 2 minutes, he's not allowed to have a gun in his possession.
Yes.
So, and I know you rely on the Payne case as well, which I think is very different because there the DNA in this case is on the object that's illegal, as opposed to the DNA being on the window of the inside of a vehicle that's used in a crime. Isn't there a big difference between that? In other words, if his DNA was found on some, cup near the gun, that would be more like the Payne case versus the DNA actually found on the gun. Would you agree with that?
I would agree with that. I think what you're suggesting is here, if he touches the gun, that is the offense in and of itself, although subject to the intent, which is what Beverly speaks to. So if he inadvertently touches a gun or he bumps against a gun, he doesn't possess a gun for purposes of our statute. So I would agree with you that yes, the act of touching the gun coupled with the requisite intent is a crime, and that does distinguish the case from Payne. But also I think that the consideration that has to be factored in here is that in Payne, I mean, he has to actually touch the surface. Here, Mr. Dawson merely needs to be present, and there is I wouldn't say a likelihood, I would say there's an equal likelihood that his DNA could be there as a result of innocent conduct, as opposed to criminal conduct.
Okay.
And that's similar to the antithesis. I'm sorry, Your Honor, go ahead.
No, I understand. And I noticed Justice Adoria and Justice Ecker both had their hands up, so I don't want to overwhelm the time. It would be a very different case, though, if he, like the other four people or 3 or 4 people on the bench had been excluded, his DNA had been excluded from the gun, it would be a very different situation. It would be strictly proximity. Do you agree with that? I mean, I don't know if the state, maybe they would have charged him anyway, but the DNA is what really led to the charge, it seems like. Do you agree with that?
Well, that's correct, because he actually wasn't charged until January. So the incident was in August, and he actually wasn't charged with the offense until January after the DNA results were returned. I would just simply point out that not everyone who was present was tested. And the point that we've made in our brief, probably ad nauseum, is that when you're talking about such a small sample space, the inferences that can be drawn from that are limited.
Thank you, Attorney Barber. I don't want to take up all your time, and I notice my colleagues have their hands up. Thank you.
Yeah.
Justice Ecker, then Justice Doria.
Counsel, was there any expert? I mean, it strikes me that the only thing the jury knows about the significance or meaning of the DNA evidence is what an expert tells them. Maybe that's just debatable, but I don't think so. If Attorney Walker wants to tell me otherwise, that's fine. But since I think that's true, was there any expert evidence here that about the probability, statistical probability that DNA ended up on the gun as a result of touch rather than some from some other application?
No, Your Honor, and I don't believe she would have been allowed to testify to that. There was some conversation in the preliminary stages of her testimony where she's asked about, generally speaking, about touch DNA and ways in which it's commonly transferred. But when she's asked about this specific case, she's very candid and says that she cannot make any prediction in terms of how the DNA ended up on the gun. And then also, I believe at some point she even states specifically when she's being asked in another context about whether or not she can assign a statistical likelihood to transfer DNA when you're talking about the laboratory setting, she's quite clear that she cannot do it in that case either.
So how can the jury determine? I mean, the question isn't whether it was a reasonable determination. The question is whether the jury had sufficient evidence to determine beyond a reasonable doubt that there was possession. And without the expert testimony, maybe this is a better question for Attorney Walker. Without the expert testimony, how could this jury have determined that the DNA evidence was there because of possession as opposed to for some other reason?
Well, I believe Attorney Walker has identified the circumstances that the state identifies that would support that. Obviously, we disagree. The state relies heavily on Officer Lepica's testimony, as did the appellate court. And I would just add in this regard that the appellate court's decision as to the emphasis it placed on Officer Lepica's testimony evolved over a period of time. In the appellate court's initial opinion, it relied on Officer Lepica's testimony in combination with the fact that Mr. Dawson was a convicted felon. In the corrected opinion, the court issued a much broader decision, simply relying on Officer Lepica's testimony. The state also identifies that he's in a high crime area. I would suggest that State versus Bernori, also cited in our brief, speaks directly to this issue, that a high crime area is not a basis from which to infer that someone constructively possesses contraband. So our position in this case is no, the jury couldn't make that determination, and they couldn't make it because the DNA was synonymous with proximity, and that all of the other circumstances that the state identifies are also synonymous with proximity. And our case law is clear that there must be something beyond that to establish guilt beyond a reasonable doubt.
Thank you. You've answered my question. Thank you.
Thank you, Justice Ecker. Justice Doria.
Thank you. I want to go back to something you said a little earlier. You said that you said that the expert was not able to put a probability on whether the DNA ended up there by touch or some other method. But you do. You say it's equal possibility. What's the basis for that? I mean, isn't it?
I guess
is it too much for the jury to say? Well, I mean, I'm not saying it's reasonable. It's beyond reasonable doubt. I'm saying, isn't it more likely, given what they heard, that he touched it as opposed to sneezed on it? Let's say, sneezed in the area.
Your Honor, I possibly misspoke. I understand what you're saying in terms of whether or not it's equal. I think it's more so the fact that the expert is very clear that without reference to other evidence in the case, she cannot make a statement about how the DNA ends up there. So the question becomes, what is the other evidence in the case that the jury can rely on to come up with a different conclusion? In terms of whether it's more likely that it's touch versus transfer, I think her testimony is very clear that without having further information about the shedder status of the various individuals involved, the environmental factors involved, whether he's got sweaty or dry hands. I mean, there's a multitude of variables that come into play when you're talking about this type of evidence, and that's the risk that we're talking about here, is that, as Melanie Russell makes clear in her testimony, commonly DNA is found for multiple individuals in items that are recovered in a public place. And again, I think State versus Bernori is a good case because it discusses this, although obviously not in the context of DNA evidence, but in terms of sort of the burden that the state has when you're talking about a public place, as opposed to even Bernori distinguishes between a public place and non-exclusive possession in the case of an automobile or someone else's house. but a public place in particular. There's
Let me just parry with you a little bit there, because I mean, he was only there for 10 minutes and his DNA was there and the folks around him were not. And so somehow, I mean, and others' DNA was on it. I mean, do you think, I'll ask you a particular question. Do you think the jury was able to reasonably infer, based upon the fact that it was kind of out in the open, albeit at night, but it wasn't, that the gun was placed there very recently?
In terms of the gun being placed there very recently, I think that's two. I just want to make sure I understand the question, because it sounds like two separate questions. In terms of the gun being placed there recently, Officer Lupica's testimony is that it looks like it was placed there recently. It's not rusty. It's not dirty. So I think there's a reasonable inference.
I'm talking commonsensically. The gun was, as I saw the picture, pretty much out in the open. You know, somebody, you know, at some point it was daylight out and now it's not, that it likely wasn't there for days, probably wasn't there for a day. And your client was there for 10 minutes and his DNA is on it and nobody around him was. I'm not saying that's enough. I'm saying reasonable to think that it happened during that time, that his DNA got on it and not some other time.
So I think to answer the first part of your question again, I think it's reasonable to infer that the gun may have been recently placed there. In terms of whether it's reasonable to make an inference one way or another about whether or not he could have left his DNA on the gun based on the fact that he's there for 10 minutes or what have you, again, there's nothing on our record, I believe, that would give them a basis to determine that. And in fact, her testimony was very clear that when you're in contact with something or you're in contact with it for a longer time, then you're more likely to leave more DNA behind on the gun. Here, this was a very small amount of DNA, which is more consistent with indirect transfer than direct transfer. And I think that's an important point. So in terms of the two things that they could look at, and again, yes, there's a number of different variables, but in terms of the two things that we know, it's very small and it's degraded. So if you look at those two factors, then it's not consistent with having been placed on there with direct touch in the 10-minute period that he is in the courtyard. And I'm sorry,
You answered my question.
Thank you.
Justice Keller. You muted, Justice Keller.
I looked.
You're still. Oh, there you go.
I looked at the article that you put in your appendix about cell phones. Is that was in your appendix, correct?
Yes.
How does that help you?
So I think both articles, what's significant about both articles, and one thing I do want to say off the bat, there's no testimony of any degree about major and minor contributors in this case. The term major and minor contributor gets mentioned twice in the course of the testimony, one time by the prosecutor and one time by the expert, and there's never any explanation or description about what that means. So in terms of the state's reliance on that, and I would, there's a lot of reliance on that in the state's responsive brief, there's almost no testimony or none as to what that means. So to the extent that those studies reference major or minor contributors, that was not an aspect of this case. In terms of how they help this case, well, I think, Your Honor, the issue is that particularly in the glass study, 33% of the glasses have DNA from someone who's not a participant in the study, someone they can't trace to being at that location, which is significant, especially when you consider that 25% of the glasses had a contributor who was present. What I think that speaks to, Your Honor, what I think that speaks to in this particular case is that the super shedder is real. I mean, this is not some abstract thing. People shed DNA at different rates, which Melanie Russell made clear in her testimony throughout, and that's one of the variables that's difficult to account for when you're trying to say whether or not it's reasonable that the jury makes a determination one way or another.
I have a couple of other questions. Who was present who refused to give their DNA or who was not asked to give their DNA?
Your Honor, the two people on the bench, Cruz and Jefferson Sumter are the two people who are present, both of whom had a history with the police. Both of them are intoxicated at the time the police arrived, which I think leads to the fair inference that they've been present at the scene for some time. I don't know, the record does not disclose whether they were not asked or whether they did not volunteer. All 6 were detained at the scene. Yes.
So these are all the defendant's friends. They're fairly close friends. They hang out together a lot. Was there evidence of that?
No, the only evidence in terms of the relationship was between Adeline Jackson, who testifies. Adeline Jackson testified briefly at trial. He stated that he never saw Mr. Dawson with a gun. He never saw Mr. Dawson move toward a gun, and that he had known him, I believe, for quite some time from the neighborhood.
Did anyone ask the expert if this is possible? I have 2 sort of scenarios. I looked at one of the pictures in the appendix. I saw a lot of cell phones on that picnic table, and I saw beer cans, Busch beer. And then there was testimony from the expert that DNA is more transferable when it gets into a liquid, right? Yes. Now, a cold beer can might have liquid on the outside of it. So I guess I'm asking you, given that you can transfer DNA from one object to another, there's a possible scenario that someone he handed a beer can to might have touched the beer can he just touched, picked up his DNA and transferred it to the gun, or someone that shared his cell phone with him that night. They're all sitting around. People always pass around cell phones because they pass around cell phones to show pictures, et cetera, or show text messages. Could have touched his cell phone and later touched the gun and transferred his DNA. Is that plausible from what the testimony was?
I mean, so no one asked the expert about those specifics. I, reading the record, had the same observations that you do, that this is obviously a social setting. People have objects around them, cell phones, beer cans, there's a cooler, they've been socializing for some time. This speaks to one of the issues in the Gore study, which reveals that in that case, when they tested the table where somebody's cell phone was placed, they found 3 DNA contributors, 2 of whom were not present. So again, that's evidence that's just coming in from the cell phone that's placed on the table. So yeah, no, it's a real scenario. She was only asked in general terms about whether when someone touches something and then touches something else, could that lead to DNA transfer, which she said yes.
And she also said that it's more readily transferable if the DNA gets into a liquid.
Yes,
right?
she did. Yes, she did.
All right, thank you.
You're welcome.
Counsel, you seem to be arguing binary choices for the jury, and I'm not sure that they're binary. It seems to me that one scenario could be more likely than the other, but that doesn't mean the jury can't make that inference, correct?
They can if they have other evidence by which to do so. And again, that becomes the difficulty of where we draw the line when you're talking about beyond a reasonable doubt and a modicum of evidence. Because again, I mean, and these are the principles I've put in my brief, but a modicum of evidence, the issue becomes when you have a very small or slight amount of evidence, where does it become unreasonable to infer one way or another whether he possessed the firearm? And again, I would just refer to the court to the Billy case because I think that's sort of on. Billy. I'm aware of that, Your Honor. And so that I think is similar, although obviously in a different context.
Thank you, counsel. I won't even ask you the question about the difference between reasonable inference and impermissible speculation. I've never gotten the answer for that one. I never answered it myself. I believe Justice Kahn has a housekeeping matter that she needs to bring up.
Sure.
Thank you, Chief Justice. I had meant to say at the outset, with the Chief's permission, that I want to clarify something on the record. At 827, the Westlaw opinion of the trial court of the appellate court lists me as the judge presiding over this trial and this case. It's at page 827 of the your appendix, Attorney Barber, and apparently when either Westlaw or when the case was initially published, it listed me as the trial judge. I never sat in Norwalk. I never had any involvement in this case. Judge Hernandez was the trial judge. And I just wanted the record to be clear that I'm sitting on this case because I did look even at the time the petition was filed for certification and realized it was an error. It has since been fixed, but when the briefs were filed, maybe it wasn't fixed or maybe Westlaw hasn't fixed it yet. But do both counsel agree? It seems from your briefs that I had no involvement in this case.
Yes, Your Honor. I had actually observed that in the past, and I knew you did not have any involvement in the case.
Thank you.
Thank you, counsel.
State's position, no involvement.
Yes, Your Honor, I agree that you had no involvement in the case. I just was going to look at the corrected opinion and to see if you were still listed. I think the corrected opinion corrected you. That's on page A67, and of course, that is the controlling opinion at this point. Thank you.
Thank you, Chief.
Thank you very much. Counsel, please continue. We cannot see I cannot see Justice McDonald, so I don't know how much time is left. Justice McDonald?
Actually, her time is. You were spot on, Chief. You've mentioned the housekeeping just as her time was up.
Thank you very much. Counsel, you can add a grace note if you'd like. You're muted.
I'm sorry. No, yeah, my time was up. I'll address any further questions in rebuttal. Thank you.
Thank you very much. State.
Good morning, Your Honor. May it please the court. My name is Nancy Walker. I'm an assistant state's attorney, and I represent the state in this matter. Your Honors, I apologize. I almost always have a frog in my throat. I've had it for years, so please don't be alarmed if I cough or whatever. Luckily, we're very distant. Your Honors, the appellate court correctly affirmed the defendant's conviction under the well-settled standard that this court applies to sufficiency claims. As this court recently reaffirmed in Rhodes, in assessing a claim that the evidence was insufficient, the reviewing court must first construe all of the evidence as favorably as possible. That was actually in Rodriguez, with a view towards sustaining the conviction. And second, it must determine whether, from the facts so construed and the reasonable inferences that could be drawn, a jury could reasonably conclude that the cumulative force of the evidence established guilt beyond a reasonable doubt. What the defendant has to show to prevail in this appeal is that no reasonable jury could have convicted the defendant. And that is an insurmountable barrier in this case.
Attorney Walker, there's two questions. First, Justice McDonald, then Justice Doria.
Okay.
Thanks, Chief. You just mentioned that we have to look at the cumulative force of all of the evidence, and you've helpfully given us 6 bullet points on page 48 of your brief, itemizing the things that you think support that cumulative force of evidence. Is that right?
Yeah, I think that's correct.
So I'd like, I understand the last one because it's the DNA. I am struggling to understand how the first 5 items that you've articulated here as evidence support the inference that this defendant was in possession of the gun. So could you go through the first 5 and tell me specifically, for instance, why the first one is that the defendant admitted to walking alone through a housing complex in Norwalk with multiple problems, including drug dealing and trespassing. How does that support an inference that he was in possession of a gun?
Your Honor, I believe that an inference could be made on the basis of common sense that someone may feel that they want to be protected when walking alone through an area that has and was documented by the evidence had multiple problems with crime and with things that involved gun possession. I think Officer Lapika testified that he'd taken multiple guns from people during his patrols through Washington Village.
Maybe I can ask the question this way. How does that fact differentiate this defendant from every other person who was in that courtyard that evening?
That fact by itself does not, Your Honor. That
Okay.
fact.
So then just walk me through the five and show me how this, all these five issues point solely to or cumulatively to this defendant.
So he joined friends at a picnic table. The friends had already been there for some period of time, but the evidence was that he came within about 10 minutes before the police came. So although Attorney Barber spoke eloquently about the social situation, there wasn't really any evidence that he was a part of that social interaction until about 10 minutes before the police arrived. The gun looked as if it had been placed there recently. So the jury could infer from that one of the people at that picnic table, not necessarily the defendant, but one of the people at that picnic table had placed the gun there when they became aware that police were approaching. And so that takes care of the, the fourth and the fifth, that someone carrying a weapon who detects police in the area will typically stash it. That was Rapika's testimony. And then Jackson testified that those at the picnic table were alerted when the police officers approached. So you've narrowed that down to the 4 people at the picnic table. And then the defendant was the only person at the picnic table and one of the few people generally who could not be eliminated as a contributor to the DNA. And so that narrows it down to the defendant. And that's the cumulative force of the evidence in this case, from which the jury could reasonably infer that the defendant constructively possessed the revolver.
I guess my follow-up question to that would be, with the exception of the DNA item, those other 5 facts would point just as conclusively to everybody else who was present, as well as the defendant, right?
I would say to the 4 people who were present at the picnic table. The other 2 people, the evidence was that they were actually in a different part of the courtyard. So I disagree with Attorney Barber that those people are really in play in this.
Okay, thank you, counsel.
Justice Daria, then Justice Keller, then Justice Kahn.
Thank you. I don't mean to put a bow on what Justice McDonald did, but I thought, basically the state's theory, or the only explanation I can gather from your argument, is that beyond a reasonable doubt, you've shown, somebody, when the police were alerted, somebody probably at that table tossed the gun over there. And because of the trace amounts of DNA, it was most likely the defendant, and that's your beyond a reasonable doubt argument. You could break it up into 6 things, but that seems to be the theory, is that that's what happened. And I guess my question for you then is it remarkable that there might be a couple of questions here. Is it remarkable there's no fingerprints in tossing it that way? And is there evidence from the expert that would suggest that there only being a trace amount, if that's how he actually, did it, is toss it? Trace amounts would be unusual as opposed to more DNA. I don't know anything about that. Could you help me with both of those questions?
Sure. I'm going to answer the second one first because that one's a little easier. There was no evidence in the record that trace amounts of DNA are more likely to be transferred by secondary transfer or by sneezing than by touching. And in fact, the appellate court in Faust found that the fact that there was even less DNA on tape that was used to bind the victims of a robbery, that was evidence that the defendant in that case had handled the tape, as opposed to sneezing on it.
So before you get to fingerprints, that's very interesting. Was that there was no evidence. I'm not sure that helps you, that there was no evidence distinguishing between ways it gets deposited. But was there any evidence, and then I'll let you respond. Was there any evidence that it would be remarkable for someone else? I get that it might be more likely that it was the defendant, but would it be remarkable for someone else to have been able to toss it there without leaving any DNA on it?
Okay, well, let me just go back, because I don't want to indicate that there was no evidence that it would be more likely to be touch as opposed to secondary transfer. I don't think that the jury had to conclude that. I don't actually think that was the expert's testimony. One thing to keep in mind is the expert is somebody who works in the lab. She's not a juror. She's not the person to make these decisions. She did testify, and Attorney Barber brought this out, that people can touch things and their DNA is not detected on it. However, there was also testimony that the gun was swabbed very thoroughly, and I go through it in my brief, why the jury could conclude that the defendant's DNA was the one that was most present on the gun. And if your honors have questions about it, I'm happy to go through that with you, but I tried very hard in my brief to make that clear. So I don't know, does that answer your question about whether it would be remarkable for the DNA?
Yeah, I mean, we're in this zone of, is there actually reasonable doubt, or whether the jury could infer. I'll be very practically candid with you. It seems like it's maybe based on the evidence more likely that it was the defendant, because nobody else of the three, it was, if we go with your theory that it was thrown there, 10 minutes ago, I don't think you need an expert to tell me that when the police come, you might throw something that you weren't supposed to have. So somebody did that. Seems a little more likely, based on trace, that it was the defendant than the other three. But is that enough? That's what I think we're going to struggle with here.
I think that what you need to decide is that were the jury's inferences reasonable, and the state submits that they were reasonable, because let me just go through the defendant's scenario here. So the state scenario, I'm going to back up. I'm going to go through the state scenario, was that it was reasonable for the jury to infer that the defendant's DNA was on the gun because he actually brought it with him, and that he was the one that threw it near the bushes. The defendant's scenario is that somebody else brought it, because we know from common sense that somebody had to bring it. Somebody had to put it there. And we know from common sense that somehow his DNA had to get on it. So the defendant's scenario is that somebody else brought the gun and left it, and the defendant just happened to walk by 10 minutes before the police came, and either his DNA was transferred, although there's no evidence that he even shook hands with anybody, much less handed them a beer. Somehow his DNA got on there by sneezing or by secondary transfer, even though there was no evidence from which the jury could make that kind of inference. And that just happened to occur 10 minutes before the police came up and found the gun. The jury was not required. That's not equipoise in the evidence, and that the jury was not required to accept that hypothesis, as opposed to making the inferences that they did make.
What about the fingerprint? Before you move on, Justice Khan will get at this maybe better than I can. But what is that remarkable, that transaction of bringing it with him and tossing it into the bushes when he didn't know the police were coming and not leaving a fingerprint? What do you think about it?
The police officer who did the fingerprint analysis, I believe, and I'm sure that I'm sure Attorney Barber will correct me on this if I'm wrong, but I believe that he testified that it was not unusual not to find fingerprints on guns and things that people had handled.
Okay, thank you.
You're welcome.
Justice Keller.
Thank you, Chief. Attorney Walker, why isn't everything the jury did speculation based on all of the other alternatives that could be reasonably possible? In other words, first of all, it bothers me that two of the people sitting at the table didn't even give their DNA. So their DNA could have been on that gun, or they could have been one of the three unidentified people on that gun, and we don't know that. And the DNA was degenerating, was it not? It had degenerated to a point. The expert testified.
The expert testified that the DNA had degenerated somewhat.
So how could it have just been put there? How could the gun have just been put there like 10 minutes earlier then?
So there was a time, the evidence showed that there was a time lapse between the time that the gun was discovered by the police and the time when it was actually seized and put in the paper bag, etc. This also occurred in August.
Okay.
And Russell's testimony was that cool, dark, and dry conditions are the best for preserving DNA, but I think this court could take judicial notice that that cool and dry doesn't really describe August in Connecticut, so that it could be that the conditions on that particular night were such that promoted degradation of the DNA, and that, this was a conflict, and if the jury, this was sort of a conflict in the evidence, and that's what we have the jury decide, are these kinds of conflicts. That's a factual conflict. So, this court.
I think your opponent kind of sets it out right for me in the beginning of the reply brief. In every iteration of the arguments concerning the defendant's proximity to the gun, you fail to identify any evidence of incriminating conduct or control over the gun. Even when you view all of the evidence cumulatively, the trace DNA evidence doesn't get any stronger.
Well,
based on any of the other facts, apart from sheer speculation, to me.
I'm sorry you feel that way, because in the state's view, this is not speculation. In the state's view, these are reasonable inferences that the jury could have made.
Would he have been guilty of criminal possession had one of the other men tossed him the gun and he quickly hid it?
If there was evidence,
would that have been enough exclusive possession and control, or control over it?
I don't think so, Your Honor. But
and there were no DNA was found on the bullets in the gun. Is that right?
It's unclear because the bullets were swabbed at the same time as the gun. So there's no way of telling exactly where the DNA came from. Whether it came from the gun, the bullets, both. So I do want to make a point about the likelihood of secondary transfer versus primary transfer. And I think the fact that...
Counsel, before you do that, Justice Khan has a question.
Oh, I'm sorry. I apologize.
No problem. Thank you very much.
Thank you, Chief. Counsel, I have two questions. One is a follow-up to Justice Keller's question, which is, I thought I just heard you say that if, let's assume, hypothetically, the likelihood of that happening, probably unlikely, someone at that table said, you know what, I just handed Mr. Dawson, I had the gun, I just gave it to him and said, hey, put that in the bushes. Your position is that the state would not view that as a criminal act on Mr. Dawson's part. Is that correct?
I may have spoken too quickly there. I think that would be a much harder case to prove that he intentionally exercised dominion and control over it. It could be a question of hot potato. But again, that is a much closer case than what we have here. We have no evidence that anybody had the gun other than him. And the evidence that we had that he had it was his DNA found on the gun.
Now, my second question is this. In response to that, obviously that could be a possible scenario, right? That it wasn't this defendant, but that somebody else had the gun and handed it to him to throw in the bushes. Well,
Your Honor, yes. I will say yes, it's a possible situation, but there was no evidence. I think our cases are pretty clear that the state does not have to exclude any possible scenario. What it has to do is show the jury a path, and the jury saw that path, and that's what it decided.
Okay.
And you have to decide whether that path was reasonable. The state submits that it was a reasonable path, and that it's actually the most reasonable explanation of putting all the facts of this case together.
So my question is, I know that you relied on the Lynch case, but to me that's very different, where the gun is found in the dresser of a home that the defendant uses with the defendant's clothes. I mean, that's a little bit, that's very, very different. My question, though, is on the Beverly case, the Sixth Circuit Beverly case that you rely on. In that case, that you try to distinguish, I'm sorry, you don't rely on it. And I'm trying to understand how is the Beverly case really different from this case? And the Beverly case, there were only two people, and there's a bucket between them, and they're in a kitchen, and the gun is found in the bucket.
Mm-hmm.
And in that case, the court said that's not enough, right? Because trace DNA was found on the gun, and there are only two individuals. How is that case different from this case? I know it's the Sixth Circuit, but how is it different from this case? In this case, there are even more people, presumably, near the gun.
Can I just back up for a couple minutes?
Yes.
Okay, first of all, this may be a fine point. The appellate court relied on Lynch. I don't believe I even cited Lynch.
Okay, yes, I apologize, right. Okay, I apologize. But you do distinguish Beverly.
I do distinguish Beverly. In Beverly, the evidence was a fingerprint. There was a fingerprint that was found on it. And what the Sixth Circuit determined was that there was no way of saying when that fingerprint was impressed. Now, I have a lot of trouble with Beverly. I believe that it was not rightly decided. And the Sixth Circuit has really moved away from Beverly. I think in that Deshanga case that I cite, they seem to say that Beverly was decided really because it was only proximity. I believe that proximity in a fingerprint probably should be enough, and that was the situation in a case that that the defendant cited. I believe it's United States versus Soto. In that case, the evidence was insufficient to find that the defendant had possessed like 3 pistols that were found in a van where he was also traveling, but was sufficient to prove that he had possession over a sawed-off shotgun where his fingerprint was found on tape around the sawed-off shotgun. So that's a Ninth Circuit case.
And I guess my last question is this: it appears that the officer, is it I may be mispronouncing it, Lepeka's testimony, he clearly testified that he did not see the defendant, Mr. Dawson, move or make any kind of furtive movement. And there was no testimony of that Mr. Dawson moved from his seated location, correct?
That's correct. There was no testimony. I would agree with Attorney Barber. No testimony of any incriminating conduct. I do want to point out that it's not just incriminating conduct; it's also incriminating circumstances. And two of the main circumstances are that the gun was found, 5 feet from the defendant, and that the gun looked like it had recently been placed there, in addition to the fact that his DNA was on it.
And if you did not have Officer Lepeka's testimony, would the state's case, in your view, still stand? If you didn't have his testimony about how he located the gun, just all you had was the picture of the gun.
If there was no testimony from which the jury could have determined that it had recently been placed there,
correct?
If you're asking, that would be a harder case.
Thank you. I see my colleagues have hands up. Thank you, counsel.
Justice McDonald.
Thanks, Chief. I want to go back to a question that Justice Keller asked, because I'm not certain I understood the state's position. With the testimony that it looked like the gun had recently been placed there, how does that get squared with the degraded nature of the DNA that was found on the recently placed gun?
It gets squared in a couple of different ways. One is that, okay, thank you. One is that this event occurred in August when it's often hot and humid. The state concedes that it happened at night, so it was dark. So the heat and the humidity are things that the expert testified contribute to degradation. Second, that there was a period of time, we don't really know how long that period of time was between the discovery of the gun and actually seizing it and putting it in the paper bag, which is when the expert testified that once it's seized and stored correctly, that probably no more degradation will happen. So there was that time period. And then the other thing is that the jury was fully aware that the expert testified that there was some degradation, and and then what Lepeka testified to in terms of the timing of both his discovery of the gun and the finding and the seizure of the gun.
And my final question is, and I'm asking it in isolation. You can answer it in isolation, or you can answer it in context. You can answer it however you want. But what is the legal significance of the fact that somebody said police when police entered the area? I mean, there was no rustling. There was nobody running. They just sat there with no distinguishing actions and just said police. What's the legal significance of that?
I'm not sure there's a legal significance. There's a factual significance, which is that it alerted the people at the table that police were approaching.
Right, but nobody, none of the police or anybody else said after the alert was when the gun was disposed of, right? I mean, the police saw them and they didn't see anybody throw a gun, did they?
Well, the police were approaching. There was evidence that the police were coming down the alleyway with a flashlight, and that somebody So there was evidence that somebody could have detected their approach, at which time, I believe I say in my brief that that was the moment when the defendant tossed the gun onto the retaining wall where it was eventually found.
Thank you.
Justice Doria?
Just a quick factual question as you're talking about them coming down the alley. I don't have all the exhibits. I'm looking from your appendix. Where did the officer with the flashlight walk toward the gun? I guess I could hold it up, but there's a retaining wall right behind where the defendant would be sitting on the bench. And did he walk down that retaining wall and shine and see the gun right in front of him essentially, or was he on? It looks like to be the other retaining wall.
I'm sorry, may I answer this question? So if you look at, I think it's exhibit, it's A84 in the defendant's appendix.
I'm with you. Yep.
Okay. You can't really even see the alleyway where the officers entered, but there's an alleyway. There's another exhibit that shows that there's an alleyway that has a clothesline.
Okay, I get it.
My recollection is that they were coming this way.
Okay.
And then they entered the courtyard from here. So they were entering, they had their flashlights. So somebody sitting over here possibly could have seen the flashlight. There also was testimony that the police do routine patrols. And so the jury could infer that people who frequent the area would know that, the patrols are coming.
And so did the officer get up on the retaining wall that was behind the defendant? That looks like the only way.
Yeah, I believe that that's correct.
Okay.
They came around over here by the picnic table, and that the officer then, Lapika, just kind of jumped up on these retaining walls.
Okay, I get it. Thank you.
All right. Thank you. So the state would ask that this court affirm the appellate court. And
Thank you,
the conviction of the defendant. Thank you.
Thank you very much, counsel. Attorney Barber.
Thank you, Your Honor. Can everyone hear me?
Yes, counsel.
Thank you. So just a few factual points. I don't believe there's anything in the record as to who says police or anything with respect to them being alerted. It's clear if someone says police, it could be the police. There's nothing in the record in terms of an advanced warning. It was something the state said that there was no evidence that he shook hands, sneezed, or etc. State made that argument below as well. The state suggested it would be speculation for the jury to infer that there was secondary transfer. Our position is it was speculation to infer it was direct. There was no evidence one way or another. And obviously the defendant had no burden to put on evidence that he sneezed or that he shook hands or that he smoked a pack of cigarettes that somebody else was smoking, etc. So I'd like to say that. With respect to the harder question as to if he inadvertently touched the gun, again, I think we've cited the federal cases that speak to, there must be specific intent here, which also requires that he is going to later reduce this to his possession. So an inadvertent touching of the gun would not establish constructive possession in this case. The state was tasked with proving that he had the power over a gun and that he intended to exercise the control over that gun. And I see that Justice Khan has a question. I'm getting better at seeing these hands.
Thank you, counsel. Justice Khan.
Thank you, Chief. It's a factual clarification as well. It was my understanding that everyone seated near that table, that picnic table that was closest to the wall behind it, where the gun was found, their DNA was tested.
Yes.
And that the people who were not tested were another group of people sitting further away from that wall. But I wanted clarification on that, if you would.
Yes, Your Honor. So looking again at A84 and A85 of the defendant's brief, the 4 people who are seated at the picnic table, actually, I should clarify that. Brian Elmore, I believe, may be at the table or near the table, but he actually leaves when the police arrive. So Brian Elmore leaves when the police approach, and then he sometime later returns. So the 4 people, which is Mr. Dawson, Mr. Jackson, who's seated to his left, and Kason Sumter and Brian Elmore, who's standing and going back and forth, their DNA is tested. The testimony is that Janet Cruz and Brian Sumter, and I'm sorry, I could be confusing my Sumters, but the other Mr. Sumter, they're at the nearby bench. All 6 are detained. 4 have their DNA tested, the ones who are at the picnic table.
So you're saying that bench that's seen on A84 right next to the table, the 2 individuals at that bench were not tested, is that?
Your Honor, there's 2 benches.
Shaking her head saying no.
Yeah,
I thought they were on another bench or another area.
So there's
am I reading the facts wrong?
There's another bench also in the photograph. It's not clear to me from the testimony. They keep referring to a red sticker, that's what the record discloses. I only know, Your Honor, that all 6 of the people are detained when the police arrive and questioned. 4 of them provide a DNA sample.
Okay, so you don't know those additional 2 who were not tested. You don't know if it was that bench that can be seen on 84 or there's another bench sort of opposite the wall, behind the wall partly. You don't know if they were at that bench.
Your Honor, I don't. I'm sorry.
Okay. Thank you. Sorry.
Also, in terms of the photograph of the gun, I do want to make clear, too, that Officer Lepica is questioned about the photograph, and he does state in his testimony that he believes, I believe he states that Officer Capello, who took the photographs of the gun, would have been using a flash camera, or he attributes light in the photograph to lights shining behind them. It's not clear what he's speaking about in terms of lights shining behind him, but at that point in time, they brought in other officers as backup at that point in time when they're securing the scene and taking photographs.
Thank you, counsel. This is a question from Justice Eckert.
Yes.
I'm just wondering, I probably should know the answer to this, so I apologize. Was there expert testimony about what degraded DNA signifies, what it means, things like that?
I believe the testimony is that it's more consistent with having been left on the gun for a longer period of time. But as Attorney Walker suggested, environmental factors, being left out in the sun or in the rain, could contribute to the degraded DNA. In terms of counsel's
I looked up on my phone.
That half-life.
Attorney Walker asked us to take judicial notice of the weather. So this is outside the record and probably has no relevance, and I'm not suggesting I'm going to consider it. Just, it's probably better than taking judicial notice that it was hot. According to one website, it was about, in the 70s and clear. It was high 70s and clear on that day. But according to this website, it wasn't raining. So there was some testimony from the expert about factors that could cause degradation.
Yes, Your Honor. Heat, being left out in the rain or the sun. She also testified that if the gun had been properly stored and bagged, that it would be unlikely that the DNA would be degraded in that instance.
And this happened at 9:30 at night?
Yes, it did. It was 9:30 at night. Also, in terms of the testimony about Mr. Dawson's conduct when the police arrived, I do want to make clear, too, that in addition to Officer Lepica, Officer Pugliese testified, and he was specifically asked about by the prosecution where his attention was focused when he approached the group. He stated that he was focused on the group as a whole. When he was asked by the prosecutor whether he would have identified or seen any incriminating conduct by Mr. Dawson, he stated that he would have, and he did not. So I want to make it clear that it's unrefuted on this record that there was no conduct by Mr. Dawson that was incriminating in any sense. And to that note, just picking up on what Justice McDonald said, oh, I'm sorry. And I see that my time is up. Thank you, Your Honor. We'd ask that the judge be reversed.
Thank you very much, counsel. Appreciate that. I want to thank both counsels for coming in and doing our virtual argument today. We really appreciate it. I will see the justices in our virtual conference room at 12:15. Thank you very much. With that, we are adjourned until tomorrow morning.
Thank you, Your Honor.
Take care.